I'm a big believer in second chances, even for people who commit serious crimes. Who deserves a second chance? Who gets one? And who decides? I'm Jessica Henry, and I'll be your host of Just Justice. I'm a former public defender, a professor of justice studies, and an award-winning author. And I'm excited for us to find new ways to put justice back into our criminal legal system. Hello and welcome to Just Justice. My name is Jessica Henry and I'll be your host. Today we have the pleasure of welcoming Marissa Bluestine to the show. Marissa is the Assistant Director of the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey School of Law. Bluestine joined the Quattrone Center after a decade leading the Pennsylvania Innocence Project, a nonprofit dedicated to securing exoneration for individuals wrongly convicted of crimes. Bluestine has also been repeatedly recognized for her important work, receiving the Andrew Hamilton Award from the Philadelphia Bar Association and the Women of Distinction Award from the Philadelphia Legal Intelligencer. Marissa, welcome to the show. I'm so excited to have you on to talk about the important work that you're doing at the Quattrone Center. And today we're going to be talking about something called conviction integrity units, which are often called CIUs. And I've also heard the term conviction review unit, CRU. So which do you prefer?
Sure. Well, first of all, thanks so much for having me. I'm just really happy to have this conversation with you and, of course, with your listeners. So conviction integrity units or conviction review units are really the same thing. We, as an institution at the Quattrone Center, tend to prefer the conviction review title, but I think we've lost that battle because most of the units that are coming online are using the term CIU, conviction integrity unit. Although we'll also see post-conviction justice unit. There are a lot of different ways that, and because it's really up to the individual prosecutor's office, how they want to call it and where they want the emphasis to be for that particular unit.
So we'll use CIU, but before we go any further at all, what is a CIU? We started talking about what we should call it before we defined it. So tell us, what is it?
It's a term that people are hearing a lot, but I think a lot of people just don't really understand what it is. So happy to answer that. So a conviction integrity unit or conviction review unit is a specialized unit within a prosecutor's office that looks to, well, ideally kind of looks both backward to review cases that they've prosecuted in the past that may not have been accurate, and also look forward in terms of how do we learn from those errors in the criminal legal system to prevent them from happening again. But all units are focused at least in looking back to identify cases where the office has prosecuted a case where maybe it was based on incorrect information, witnesses who may have lied, may have not been telling the truth, outdated science, or other ways that a conviction may not have gone correctly. So it's a way to correct an injustice of a wrongly convicted individual. Most have that focus and most will focus on actual innocence. And it's still kind of hard, I think, for people to believe, but we actually do in the United States convict people of crimes they did not commit, sometimes in cases, as you well know, where there was no crime at all. And so the CIU is the prosecutor's way of working to correct that injustice.
It's a really interesting thing, this idea that prosecutors can get involved and look backwards and say, whoa, we did something wrong. But why do we need CIUs? Like, why can't people just appeal their sentence? If they're innocent, why can't they just go to the courts and say, hey, this was wrong?
Well, they can, of course. And there are hundreds of cases that get reversed and corrected through that mechanism every year. But I think people don't really understand that our appeal system, first of all, you get your first appeal, which we call a direct appeal. And that's just all you're able to raise there are questions that happen during the trial. The judge made this error. The judge should have overruled this objection. The judge should have allowed this juror to sit. The judge should not have allowed that testimony. But you have to kind of look at literally the four corners of the document of the trial transcript and be able to point to it and say, right here, this is where the problem was. The second layer of review we have, which is called post-conviction, does allow new evidence to come forward and to come in to the court for their consideration. But the way our courts are set up, they are set up to protect the conviction, not to challenge it. So too often what the courts are doing is looking at that through a very, very narrow lens of whether a procedural error happened. These cases of innocence require a really different view of the system and looking at it all over again, like from a whole new angle. And where the CIUs come in particular, is they allow prosecutors to do in-depth investigations of cases rather than just look at the case on the pleadings or on the paperwork. They're out interviewing witnesses, talking to experts, having new evidence reviewed and tested. They're actually doing a full investigation of a case where it may not have gotten the correct outcome. And that's what's different.
And can you maybe give us an example just to set the stage for us? Like, can you tell us about somebody who was helped by a CIU?
I certainly can. I represented many individuals who were helped by working with the Conviction Integrity Unit when I was at the Pennsylvania Innocence Project. So, for example, my client, Dante Rollins, was convicted of a shooting that had occurred when he was actually shopping with his friends in a district that was miles away from the shooting. But at the time of the shooting, the victims, or rather the victim's grandmother who was in the car, saw the shooters and thought one of them was Dante, was my client. And of course it was not. He was not there, but he was convicted of this shooting. But at the trial, the defense lawyer did not put on evidence of innocence. There was video of him shopping at this place. There were cell phone records of him being on the phone. We contacted the people who were on the other side of those conversations. They all agreed. And we took all that information to the district attorney's office that was under the previous administration. And we worked with them to develop that evidence of innocence. And we were able to, with their cooperation, go into court, present the evidence to the judge, with the district attorney helping to support the claim. And we were able to eventually get that conviction overturned. But more often, it's a case where there's information that is contained within a police file or a prosecutor's file, which has never been turned over to the defense. And that information very often points in a different direction, has information about a particular witness who testified, who may not have been that credible. Maybe they give multiple statements. They only gave over one. So a critical action that a CIU can take is to provide that information to the defense counsel. And that happened in many of my cases and led to what we call an exoneration, somebody walking out of prison, having the conviction reversed, their sentence reversed, all the charges withdrawn on the basis of information which supports an innocence claim.
Yeah, it's fascinating. But let me ask you a question. So how does it work in practice? Like you just said, a lot of these exonerations come about because an earlier prosecutor, the original prosecutor, maybe didn't turn over evidence in their case file that they were supposed to, that they were required under the Constitution to turn over. And so when you go back to the CIU, even if it's not the same prosecutor, even if they've left the office or whatever, isn't there sort of a conflict of interest or tension in that office when you're asking a CIU to go back over a case that their very own office was responsible for obtaining that conviction?
A lot of people have that skepticism. I talk about this issue all around the country, and very often the phrase "the fox guarding the henhouse" comes up, right? There seems to be this conflict. But when done right and correctly, a conviction integrity unit actually can be objective. They can look at cases, even that their own office prosecuted, through a new lens, through a new eye. Very often they do that by bringing in someone from outside the office to run the unit, somebody with defense counsel experience, for example, or having been an innocence lawyer like I was. But even if the unit is run by somebody who's from that office, and I'm thinking in particular, Bexar County, Texas, which is San Antonio, their unit is run by a lifelong prosecutor who is fantastic and does a great job because he took it on knowing mistakes are made. And it was his job to try to find that out. Now, if that prosecutor knows or is friends with the prosecutor who tried the case initially, or the police officers who are involved, very often they'll recuse themselves off that case and have their colleagues look at the case. So it is absolutely possible to have a unit run even by lifelong district attorneys or prosecutors with that objective eye, but it's usually better to bring in somebody from the outside to conduct those investigations.
I mean, I could really imagine that if you're in a CIU working as a prosecutor, looking back at old cases that your own office prosecuted, it could really create tensions with existing prosecutors. And also, it could create tensions, I would assume, like if you're talking about a case, for instance, where perhaps the police planted evidence or engaged in misconduct that led to a wrongful conviction. And again, that happens, unfortunately, far too frequently in the innocence space. I could see how current prosecutors say, we don't want you doing this because we need the police in our current cases and you're going to mess up our relationship. So have you seen that happen?
Of course. And usually when we're talking about information which is withheld, the majority of the time that's from the police not giving it to the prosecutor, as opposed to the prosecutor not giving it to defense counsel. But I think most people don't understand that, unlike in the civil system, if you file a civil lawsuit, right, against your neighbor because their dog bit your cat or something, there's lots and lots of information that gets exchanged between your counsel and the defense counsel. It's very open. You get interrogatories, you get requests for admissions, all kinds of stuff. In the criminal space, it's very, very different. The prosecutor controls what goes over to the defense. And yes, they have to follow the law. They have to follow the Constitution, which says anything that's exculpatory has to be handed over, but mistakes get made. So the prosecutor may have a full file, but the defense lawyer only gets a small portion of that. And that's allowed under the Constitution. But if the prosecutor doesn't have what the police gave them, then that compounds the error. So yes, we do see some pushback from police to these offices saying, we're not going to cooperate in this, or we're going to slow walk it because they're a little more protective of their folks. But yes, even within the office themselves, sometimes what we call line prosecutors who are trying cases or doing the appeals, will have some concerns about how the integrity unit goes about its work. But when done properly and openly and with transparency, those relationships can move forward and not be a barrier to the unit's operation.
So the CIU thing, it's not new, but it's relatively new. Can you sort of tell us how many CIUs there are? Is there one in every single prosecutor's office?
Oh, no, far from it. So the first one started in Santa Clara, California in 2003. And then a couple years later in Dallas, Texas, Craig Watkins, who was the district attorney there, also started a unit, a very robust unit that was focused on testing DNA from old cases. He was singularly focused on that at the time. So from that, it's grown. By our count at the Quattrone Center, there are 130 units that are operating in the United States. Another organization that tracks the National Registry of Exonerations, they have about 102 on their list. I will say I have a very active Google alert for conviction integrity units. And anytime one is announced or identified, we reach out to try to offer assistance to them for that. But 130 sounds pretty good. And I should know the number off the top of my head, but probably a couple thousand or 3,000 prosecutor offices in the country. So we're still talking about a fairly small percentage of offices. But when it comes to large offices in major metropolitan areas or large urban areas, every state has a unit in a large office like that where they have the resource.
So out of these 130 CIUs, are most housed at that county level like we were just talking about? Or have you seen models where it's the state that runs and oversees all of the prosecutor CIUs in the state?
It's a great question. So yes, the vast majority of those are at the county level, where prosecutors are usually elected by their constituencies. But there are a number of states that have a statewide unit. So California, Illinois, Michigan, Pennsylvania, Virginia, Massachusetts is starting one now. And I think Missouri will have to start one under legislation next year, although it's not funded. So there's some questions about that. New Jersey, also Delaware. So it gets a little bit tricky because in some of those states, it's easy. New Jersey and Delaware, the state attorney general is also the local prosecutor. So it's all kind of one system. But then you might have a state like my own, Pennsylvania, where you have an attorney general who has very limited, what we call jurisdiction or power. They can only take on certain types of cases. Everything else is led up to the counties. We have 67 counties here. So if the state attorney general's office wants to look at a case, say in Elk County, yes, we do have an Elk County. So it's a very lovely county.
Do they have elk?
Oh, yes, they do. One ran in front of my car one day.
Oh my gosh.
So if they want to look at a case in Elk County, they need that district attorney's permission to do that. They can't just go in, grab the file and say, we're looking at this. So there's a level of, I don't want to say politics, but relationship building that needs to be done between the state and the counties in order to do that well. So it can get a little bit tricky in that. Minnesota also, which I neglected to mention, does have a statewide conviction review unit. Same thing. They have limited jurisdiction. And we're seeing some interesting things there where the state office actually has conducted a thorough review, said, we think this person should be exonerated, but they don't have the power to go into court and say, Judge, you should overturn this conviction. That has to be done by the local district attorney. And then they can take it from there. Because remember, the prosecutor can't unilaterally just say, oh, we think this guy should be out and he gets out. We still have to go to court and the judge still has to make that decision. In the criminal system, the judge has to make the decision. Once charges are filed, everything has to go before a judge, even agreed upon exonerations.
Yeah. And so like in the example you were just giving in Minnesota, even if the state's attorney general says, let's exonerate this person, let's support a motion to exonerate this person, the local prosecutor, the local elected prosecutor might say, I don't want to do that. I'm not going to. And then that person is in some kind of legal limbo.
And that's exactly what's happening right now, where the state's attorney general has said, in a particular case, we think that this person should be exonerated. The local district attorney is fighting it. So now the innocence organization there, called the Great North Innocence Project, they're in court trying to exonerate the individual, and the prosecutor's office, well, they haven't yet filed a motion saying that they oppose, but they're not agreeing yet. So the attorney general's office is there saying, we did this full review. We think he's innocent, but the local state's attorney is still not quite on board, let's say.
Didn't that just happen recently? Maybe it wasn't a CIU case, but in the death penalty case with Marcellus Williams.
That's right.
Right?
Yes.
The county prosecutor, who had a lot more information about the case, said this guy is innocent. We prosecuted and convicted an innocent person. And the state attorney general said, no, we're not going to support this. And so there's that tension that existed. Yeah. And unfortunately, in Mr. Williams' case, he was executed.
He actually was. Yes. And there in Missouri, the way their law is set up, it allows the state attorney general to step in those cases if they want to. And the attorney, as far as I know, in Missouri, the state attorney general's office has opposed every exoneration that has gone forward. They even had a very lengthy hearing 2 summers ago in a case where it was prosecutor's office against prosecutor's office. It was the state attorney general's office versus the conviction integrity unit from St. Louis, literally having a fight in court over the innocence of an individual who was exonerated. And the judge was none too kind to the state attorney general and the positions they took through the exoneration. So yes, it can be. It doesn't have to be, though. Michigan, their conviction review unit has had several exonerations with the cooperation of the local district attorney. So it's a model that's evolving.
Again, I think to your earlier point, when you say it doesn't necessarily have to be political, it often is because there are folks who are elected and are concerned about currying favor with one constituency over another. And, you know, the idea of innocence or just injustice gets a little bit lost in the shuffle. So let's just go back to some basics, though. How does a case even get to be considered by a CIU? Like, does the person who is wrongly convicted or incarcerated send a letter, or how do the cases get to the CIUs?
Very often, that's exactly right. The individual who is claiming to have been wrongly convicted will write to the conviction integrity unit directly and say, I want to have my case reviewed. Or it could come from a defense attorney or an innocence organization. So there are about 63 or so independent innocence organizations around the country, often using the name Innocence Project. They're not all one unit. They're 63 individual organizations. So that organization, maybe they'll contact the unit and say, we have a case we've been looking at. Or a judge could say, I had this case, I have some concerns. Or a prosecutor can come to the unit to say, I'm glad you're here. I have this case. Police have referred cases to a conviction integrity unit. So they can come really from anywhere in the community or from stakeholders.
What's the criteria internally? So someone writes a letter or someone makes a referral and says, hey, CIU, I really think you need to look at this case.
So there's no one way to do it. There's no requirements of any kind for a unit. But generally speaking, first of all, the unit can only take on cases that are from their jurisdiction. So I live in Philadelphia. If I'm writing and the case involves something in Pittsburgh, they can't take the case. If I have a case that's in Michigan, they can't take the case. It has to be my county, my jurisdiction. Then they're also looking at cases where they can actually do something. So if the case has been completed, the person has served their sentence. In most jurisdictions, sadly, the prosecutor is powerless to try to rectify that. So the person usually has to be serving the sentence of some kind. And generally, they were looking for people who are claiming actual innocence. I wasn't there. I didn't do this crime. I had nothing to do with this crime. And if those are the basis for the person reaching out, then usually they'll kind of move it to another stage where now they're going to start looking at the records. They'll pull their own file. They'll look through the case file. They'll look through the opinions, get some more information about a case and start to develop it from there. Very often CIUs will use an application of kind so that it kind of gives the applicant an idea of what kinds of cases they're looking for. And they use that information to try to figure out which cases to move for investigation and which maybe aren't as urgent or cases that are not appropriate for them to look at.
So from what I understand, there's been about 780 exonerations that have come with the help of a CIU, which is about 20% of all known exonerations in the United States. That's a fairly significant percentage where the prosecutor has actually been part of the solution.
Yes. And if you look at the numbers over the most recent year, right, because those are exonerations from 1989 forward. But if you look at cases from, say, 2020, 2021, 2022, 2023, it's more like 40 to 50% of those cases in some years are with the help of a CIU. That's not saying that those cases would not have been exonerations without the help, but they're certainly playing a very important role.
Particular kind of case that you see CIUs being very effective in terms of getting exonerations? Like I'm thinking here about drug cases in Harris County or something like that.
That's the great example, right? In Harris County, which is Houston, Texas, the Conviction Integrity Unit was able to look at a whole swath of cases. And I think in one year they had 50 exonerations just on the drug cases because they can say, okay, we know there's a problem with this officer or this squad or this pattern. They can actually go back and look for those cases on their own and say, okay, we're going to actively look for these cases and try to fix them. Cook County did the same kind of thing with some of their problematic investigators from the police department. So they have that ability to do what we call audits of cases involving particular bad actors or old methodology or things like that. Without that specialized unit, then it kind of becomes a hot potato in the office of who's going to handle, not me, I've got too much to do, right? But that's right within the Conviction Integrity Unit's mission. So it makes sense for them to be doing those kinds of cases.
Are some CIUs more effective than others?
Oh, undoubtedly. Sure.
And why would that be?
There are a lot of reasons for that or ways of kind of thinking about that. Look, there are some units in the country that are what gets referred to as crinos by a professor at Harvard Law School, came up with the term of conviction review in name only. So I always have to hat tip to Ron Sullivan for that terminology. And those tend to be units which are more about the prosecutor trying to either look good or trying to be responsive. So if you looked at Philadelphia's unit, for example, when it first started under Seth Williams, who was the prior administration, the unit had one individual. The individual was a former homicide prosecutor, had been a homicide prosecutor for about 20 years. They gave him no other staff, no information, no ability to kind of do his job. It was under the habeas and appellate unit in the office. It was not an independent unit. And then within about 6 weeks of his appointment, he was also appointed to work on very heavy cases of potential corruption in Harrisburg, which is our state capital. So if you were to quote President Biden on that with his, don't tell me your values, show me your budget, and I'll tell you your values. That's a pretty good indicator it was not a high value for that administrator. So once Mr. Williams kind of left the office, the interim district attorney revamped it with more staff, more transparency, more independence, moved it out of the appellate unit. And then, of course, when Larry Krasner became the elected district attorney, he put many, many more resources in. And the unit has been extraordinarily active since his election. So even looking at one unit, you can kind of see it go from a pretty clear crino into a well-functioning unit. And what's the difference? More transparency, clearer policies, more resources, and putting it outside of the appellate unit or the trial unit, making its own unit in the office and having it run by people who are really dedicated to the mission. So yes, units can be ineffective. Units can be very effective. The one thing I would say, though, is that we shouldn't be using the number of exonerations only as a metric for whether a unit is or is not successful, because there are many units which don't have exonerations or have very few, but I would say are very well run, are open, are transparent, are trying to do and are doing a very good job. So it gets a little tricky or it's somewhat nuanced maybe on some of those questions.
Yeah, because I would think, as an outsider looking in, that you look at a CIA, you're looking to see how many people they really are able to get out, because we know that there's a lot of innocent people who are incarcerated who don't necessarily have a path forward.
That's right. And that's what the CIUs are there for. But you have to remember, with an exoneration, with getting somebody all the way through where their conviction is vacated, their sentence is vacated, the district attorney drops the charges, includes an insane amount of luck. Right? The witnesses have to be alive and willing to talk to you. Evidence has to be available and subject to testing. You have to be able to find the file and find the information. And all of those tiny little dominoes have to fall in precisely the right way at precisely the right time in order to get to that outcome. And much more frequently, where a prosecutor's office through a CIU will conduct an investigation and say, yes, we don't have faith in this conviction because it was gotten through improper means or bad evidence, but we're not convinced he's innocent, that we still think that there's some residual participation in the crime. So then they do what we at the center called case corrections, where they will go into court, advocate for the conviction and sentence to be withdrawn, but then they'll either retry the individual or maybe come to an agreement as to some kind of lesser plea, instead of first-degree murder, third-degree murder, or manslaughter, and a time-served sentence. And those cases are much more numerous than exonerations, but a little harder to track.
So, I was going to get to that in a little bit. Just Justice looks at second chances. And so it's not just about innocence, not at all. Although innocence is an important thing to think about when we're thinking about second chances, for sure. But there's also the role of the CIU in what you call case corrections. And that is something that's really interesting, right? It's when prosecutor offices may look at a case and be like, I don't know if he's innocent or not, but the sentence sure doesn't feel right to me. Or I don't know if he's innocent or not, but I don't really care because look at what he's done in the last 30 years of his sentence. And so the outcomes from case corrections at CIUs, you think, are actually more numerous than exonerations? Could you give me maybe an example?
Sure. So if you look at Suffolk County, Massachusetts, that's Boston, they've had a number of cases go through their unit, which are not exonerations, but case corrections. And I think maybe just one or two exonerations, actual exonerations, where they've gone through, sentence has been reversed, convictions reversed, and they withdraw all the charges. So it would be unfair to say that that unit is not being successful simply because they're not getting cases all the way to exoneration. But if you look at the case correction numbers instead, they're getting people out of prison, they're adjusting the cases, and you're able to have that person released under different circumstances than what they went in.
So what would be an example of a case where that happened?
So there have been several here in Philadelphia, for example, where an individual has gone through, and thinking of a couple cases in particular, but the district, so we had very early on represented an individual who had been convicted of a murder that had happened at a bar. And the district attorney's office provided information to us, which showed that the photo arrays, which is a way to identify a particular suspect, where you usually have anywhere 6 to 8 photographs on an individual piece of paper that's shown to a witness, and the witness can see whether or not they recognize anyone. The witness had actually seen a photo array that identified somebody else, not our client, on that. And there were a few other pieces of information which were turned over, which shouldn't have been. Now, the district attorney's office still felt that he had been involved in the crime for reasons that were never, frankly, quite clear to me. But what they said was the case has been reversed. We're going to retry it. And it's going to take us about a year or so to retry him, or he can walk out the prison tomorrow if he pleads no contest to a third-degree murder. And the client really had to struggle with that question because he knew that he hadn't been involved. I frankly believed he hadn't been involved either, but he was getting older. He hadn't seen his children, hadn't been with his family. He wanted to take that certainty of getting the deal and walking out of the prison. So it can be a horrible decision for the individual who's affected to have to make that decision. But it can be because then you're risking it all again at a trial through a process that they don't have a lot of faith in because it didn't go right the first time. So there can be that certainty can be a good way to resolve those cases.
I mean, that's a heartbreaking decision for an innocent person.
It's heartbreaking. It's horrible.
An innocent person is faced with the opportunity to get released, but to admit guilt.
Or even not admit guilt, right? I mean, that particular plea, he was able to say, I'm innocent, but I'm taking this plea, but he still has a conviction on his record. So it doesn't have a functional difference other than for him to be able to go into court to say, I didn't do this, but I'm accepting the plea, but it still allows the conviction.
CIUs work, and maybe they do or maybe they don't. Can you tell me if they ever take a look at people who are factually guilty, but again, who maybe got disproportionately sentenced or where an injustice would be done if they had to remain in prison? Do CIUs ever deal with that?
It's a critically important role for the prosecutor, without a doubt. We don't advocate that a conviction integrity unit take that over because in the times when we have seen an integrity unit take that over, those cases tend to get the majority of the focus because they are a little easier to deal with because now you're not doing a full investigation. You're looking at different criteria as opposed to an in-depth investigation for a potential innocence case. And the people who run those units tell me all the time, I just don't have time to do the innocence cases. All I can do is the second look cases. It's a critically important function and needs to be done, but it should have its own dedicated staff, its own dedicated resources, as opposed to trying to split the baby and using the CIU for that purpose.
So one of the limitations of CIUs in terms of being able to do the full panoply of things that prosecutors could in theory do is they just don't have the staffing. And innocence cases are very resource intensive.
Extremely resource intensive, right? The CIU should not be the garbage disposal for the office, right? It shouldn't be getting everything that doesn't quite fit into the other units to do. Those are important structural functions which need to be done. But putting it all under the CIU without the resources to do it is an insincere effort.
So you think, in other words, offices should have a CIU unit and also a second look unit?
Sure. And there's some offices that do that have kind of a post-conviction justice unit. Part of that is a CIU, part of that is a second look, and making sure that they're taking consistent stances on those cases going forward.
One other question just about how these all work. So let's say you do get a CIU that is like, this person needs to be exonerated, and there's a defense lawyer who says this person needs to be exonerated, and they go before the judge. What happens when the judge isn't on board because perhaps the judge is elected?
It's a rare occurrence, but it's a troubling one. And this is the problem with the criminal legal system here. On the civil side, again, going back to my dog bite cat case, if the lawyers decide to settle the case together, they settle the case. The judge doesn't even know. It just disappears from their docket. But in the criminal system, once charges are filed, the judge has to approve every decision going forward, even for the district attorney to drop the charges before trial, which we call a null pros. So they have to be involved. So even in cases where the district attorney comes into court and agrees to relief, the judge can still say no based on an independent review. So if it's a truly independent review, then it can go forward and that decision will likely stand. But if it's not a fully independent review, then another court can look at it and they can overturn that decision. That just happened in Cook County last Friday, in a case called Kevin Jackson. The district attorney's office initially submitted a report, a 72-page report, which supported relief from Mr. Jackson. They go into court and the judge denied it. Just Friday, the Supreme Court, I believe, in Illinois reversed that decision, saying it was not based on a thorough independent review of the case and that needed to happen. And so it was an abuse of discretion for the judge to deny that relief, and it should have been granted. So it can get fixed through the appellate process. But luckily, that's the minority. Very, very few cases where the judge does not go along with what's being requested. Because it's not like they just kind of go into court hand in hand and we're like, okay, judge, we think you should reverse this conviction. Rather, the district attorney's office usually is giving the judge a report, which dozens of pages, if not hundreds of pages long, outline the investigation, who they talked to, what did they say, what did the testing reveal. They're laying out everything for the judge so they have the information there to make hopefully the right decision.
It's the end of October. We're heading into our election cycle. And one of the questions people, I think, ask about CIUs is that they seem to be led by progressive prosecutors. And the danger with that, of course, is that they can be voted out. And so what do you say to people who wonder about resting that kind of power in elected officials who do cycle out of their office?
So North Carolina has an independent commission which reviews cases of potential innocence, right? It was funded by the legislature. It's outside the courts altogether. That's an interesting model to do that by taking it out of the judicial process entirely, giving it an independent funding, independent staff. They can do their investigations and then they move forward. Part of the problem with that is, number one, in North Carolina, the district attorneys there say, well, we don't need a CIU because we have the Innocence Commission. And then number two, no other state has replicated that. So no other state has been willing to put the resources in to have those offices set up. We all think it's a great idea to take it out of the system altogether. But until that happens, we're kind of but we have what we have with the prosecutor's offices. And one of the reasons that we at the Quattrone Center like to encourage offices to have written policies, written procedures, make them available on your website for people to see, is it would make it a little harder, at least, to pull that back under a new administration. Because if the constituencies can see what the unit is doing, how important it is, not just for rectifying old convictions, but preventing new wrongful convictions, then there would probably be more support within the community to keep that going and even dedicating the resources to it.
Yeah, because I like to think anyway that nobody, regardless of your politics, nobody wants to see an innocent person incarcerated.
No, of course not.
So it's always an interesting question about how that all shakes out in terms of what happens on the ground and in terms of exonerations. And finally, if you could wave a magic wand, your very own Marissa magic wand, what would you say a CIU should do? What should it look like? What could it do? What is its possibilities?
I mean, the possibilities really are endless. So I like to say that a CIU, well-functioning CIU, is really the heart of a prosecutor's office, because you're now not just talking about identifying past convictions that were incorrect and inaccurate, but we're taking that information, retraining our prosecutors, looking at the system as a whole and saying, okay, how did these wrongful convictions happen? Where were the holes in the Swiss cheese, if you will, that led to that bad outcome? And how do we improve it? Look, no exoneration is ever just one person. It's always systematic errors. You have an eyewitness who is led to make an identification of the wrong person. That leads them to arrest somebody. They bring him in. They maybe want to get a confession out of him. They get the confession, and then maybe that influences the way the forensics teams looks at the forensics. So there's always this cacophony of error that can happen, this cascade of error. And so a unit that is able to do all of that, they're able to retrain and look at the system and try to fix the system broadly. That's the beating heart of a prosecutor's office. And to do that well, of course, they have to be resourced. But the office itself has to have what we refer to as a just culture, where people aren't afraid to come forward and say, I had this case, I have some concerns about it, because they don't think they're going to be like hailed to the carpet or led through a disciplinary proceeding, but rewarded for that, for coming forward and saying, okay, great, that's the right thing to do. Because just like you said, no one wants wrongful people in prison. No one. No prosecutor wants an innocent person in prison. And if it had happened and they can help to correct it, they want to do it. So to have that just culture, my wand would include that in terms of being able to have people feel comfortable coming forward and admitting, I may have made a mistake, or my colleague may have made a mistake. And to have that be the imbued of the culture of the office would make all of this work so much better.
Yeah. Mark Godsey in his book, Blind Injustice, talks about the prosecutors as innocence deniers, which is the exact opposite of what you're envisioning, this just culture, right? So the innocence deniers think like, oh, we could never have gotten it wrong. And this person is incarcerated because they have for sure committed the crime. And what you're sort of saying is, wouldn't it be amazing if prosecutor offices could embrace this just culture, this idea of if there's an error that's been made, it's something we should all sit down and examine and review so it doesn't happen again. I mean, that would be a tremendous shift in
Absolutely.
how we do justice. Yeah.
Absolutely.
Now, Marissa, we were talking about how cases kind of come to the CIU, but maybe you can also tell me, what is it like within the CIU and how do they work with or against defense attorneys or innocence projects? What's the connection between CIUs and those outside entities that are advocating for the person who's been wrongly convicted?
That's a really important issue with conviction integrity units, because unlike any other part of the criminal legal system, or mostly any other part, here it's actually encouraged that the prosecutor and defense counsel work together to investigate the case, to be able to bring it forward. So, and I always use this example. I represent a very lovely man named Chester Holman. And Chester had been convicted based largely on the testimony of an individual who wound up giving essentially a false confession. It was somebody that he was with that night. She was pressured by the police to give an inculpatory statement against Chester. They lied to her. They said he was like in the junior black mafia, it was ridiculous. They absolutely pressured her to do it. When we went to go talk to her about this, it was now 20 years after the trial. And we knocked on her door. We said who we were and what we were there for. She broke into tears and she started physically shaking because she had carried this guilt with her for all this time. And it took us a while to kind of calm her down and be able to get her statement and talk. And it was such an impactful moment for me in terms of, okay, she's absolutely telling the truth because of this visceral reaction she had. But by the time we got to the hearing 2 years later, she was calm and collected on the stand. So the prosecutor never saw that. Like, what if the prosecutor had been with me when we went to go see her and had seen that reaction of hers? So these collaborative investigations bring more resources to it, for one, but also we're in real time seeing how these investigations are developing and how they can enforce each other and make it stronger. And we're leaving no I's undotted, no T's uncrossed, but an extraordinarily thorough investigation can be done that way. And that is the model for being able to move a case through the system. So yes, it sounds weird because we're used to our adversarial clashing system. But actually, when prosecutors and defense counsel work together in an open and trusting way, which is a little hard to get them to the table sometimes, but when there's trust there and they can work together, they actually can get these cases done quicker and in a much more thorough fashion.
I don't think I